Attorney Brian Steele just went nuclear against Judge Glanville and DAs Love and Hilton. Steele filed a scathing motion to have them all removed from the YSL RICO trial. Here we will read some excerpts from the motion. A special thanks to the X account Thugger Daily for reporting on the motion and linking to it.
Coming up, you will see why Steele writes the following, so be sure to stick around until the end.
The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams's case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams's trial, and the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton.
Supplement to motion to recuse Judge Glanville.
Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby timely files this supplement to motion to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. This supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, Exhibit A, is timely filed as Uniform Superior Court Rule. 25.1 mandates that the time for filing a motion to recuse shall be not later than 5 days after the affiant first learned of the grounds for disqualifications. See Exhibit A, attached hereto, joint affidavit. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under USCR 25.1 if it is filed within 5 days after the affiant first learned of the alleged grounds for disqualification, excluding Saturdays and Sundays. Thus, this supplement to motion to recuse is timely filed as the additional reasons for this recusal were first learned on Monday, July 1st, 2024, when Judge Glanville permitted the court reporter to release to undersigned counsel the transcript of the Monday, June 10th, 2024, ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable Attorney Bumpus and her client, sworn witness Mr. Kenneth Copeland, and others. This timely filed supplement to motion to recuse has also been timely presented to the Honorable Judge Krause and Judge Glanville on Monday, July 8, 2024. In the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. See Exhibit B, attached hereto, transcript of the June 10th, 2024 ex parte hearing. Judge Glanville, Lawyer Love, and Lawyer Hilton have prejudiced and tainted Mr. Williams's trial so deeply as Judge Glanville has not acted as a judge but morphed into an essential part of the prosecution team. USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Yet Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meeting as privileged and describing the improper secrecy as sacrosanct. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Mr. Williams timely raised his objections to these ex parte communications and recusal of Judge Glanville, to wit, when he first learned of same. Canon 2, Rule 2.9 of the Georgia Code of Judicial Conduct and former Section B7 of Canon 3 forbids a judge from considering ex parte communications as judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judge Glanville embraced his view that the communications at this ex parte hearing were privileged. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside of the presence of the parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts, or court personnel in settlement conferences. Code of Judicial Conduct. Rule 2.9a. It is also clear that ex parte communications are presumed to have been in error, and once a party has shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. In the case at bar, there is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in attached Exhibit B, resulted in harm. Thus, Mr. Williams's case should be reversed on direct appeal if there is any conviction and sentence. As shown in the joint affidavit attached hereto as Exhibit OA, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County District Attorney's Office, as he dispensed legal advice and supported lawyers Hilton's and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-indictees. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings. Code of Judicial Conduct. Rule 2.11. Judge Glanville has been derelict in his judicial duties and must be recused. See Code of Judicial Conduct, Rule 2.11. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10, 2024 in open court, lawyers Hilton and Love sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams's case. In the case at hand, the state cannot show that Judge Glanville's, lawyer Love's, and/or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his two cohorts from the Fulton County District Attorney's Office on Mr. Copeland changed Mr. Copeland's stance not to testify against Mr. Williams. If Mr. Copeland refused to testify, all of his prior false, inculpatory statements as to Mr. Williams would not come into evidence based upon Mr. Williams's constitutional right to confrontation. Intimidations as tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, lawyer Love, and lawyer Hilton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. Mr. Williams's fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three public officials simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary occurred just hours or minutes before. Mr. Williams needs to examine Judge Glanville, lawyer Hilton, lawyer Love, and all other members of their prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams's case since its inception, the subject of same, and order the court reporter to produce any transcript of same and/or unseal all documents from these potential improper ex parte communications. Undersigned counsel needs to cross-examine all of these parties to ensure that the sworn testimony is spread in open court on the record. Mr. Williams's trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, lawyer Love, and lawyer Hilton, all working together in an effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams's case. Thereafter, this motion is also timely made for lawyer Love and lawyer Hilton to be removed and disqualified from Mr. Williams's trial, and the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County District Attorney's Office, and stains courts throughout the state of Georgia and our country. What occurred in this star chamber, outside of the view of the cameras, in the shadows, and hidden from Mr. Williams and his counsel and the public, is unpardonable and all in violation of Mr. Williams's constitutional rights stated herein as well as in Exhibit A. Judge Glanville, Lawyer Love, and Lawyer Hilton have created secret Star Chambers proceedings, which the state of Georgia has promised its citizens it would never engage. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and outside of the lens of the cameras. These public officials shall never be trusted by Mr. Williams or undersigned counsel. There are serious consequences for these intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and/or there is at least the appearance that Judge Glanville is not impartial. Judge Glanville must be removed, disqualified instanter from Mr. Williams's case. Judge Glanville at the indecorous Star Chamber ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under our Code of Judicial Conduct and a constitutional violation of due process. Mr. Williams's constitutional right to due process has been violated because not only is there an appearance of partiality, but there is actual bias as Judge Glanville has been embroiled in this trial and is assisting the prosecution to attempt to gain a conviction of Mr. Williams. It is impossible for any reasonable person to believe that Judge Glanville is neutral. Judge Glanville must be removed based upon the one ex parte communication that has come to light thus far. Judge Glanville, Lawyers Love, and Hilton have infected the process of Mr. Williams's trial and have illegally poisoned same forever.
See Thugger Daly's X account, linked in the description, to read the entire motion.